Vivek sir, just I'll formally introduce you so that later on we can start with the presentation. Vivek sir,
Yes, madam.
sir, just I'll take 2 minutes of time to introduce.
Yes.
Thank you, sir. Good afternoon to all. Welcome back to the 3 days online FDP on intellectual property rights in engineering educations. Day 2, session 2, topic copyrights and filing procedure. Now I call upon Mr. Girish Shyam, Assistant Professor, Department of ECE, to introduce our today's speaker, Mr. Vivek Anand Sagar, IP Attorney, Consultant, KCST, Bangalore. Over to you, sir.
Thank you, ma'am. It's my privilege to introduce today's speaker, Mr. Vivek Anand Sagar, IP Attorney, Consultant, KSCST. Mr. Vivek Anand Sagar completed his Master in Law in Business Law, Coimbatore University, Gnana Sahyadri, Shimoga. And he has done his postgraduate diploma in HR Management, Coimbatore University in 2012, MA in Sociology, Coimbatore University, and he is pursuing his PhD on enforcement of copyright issues in film and recording industry at CMR University. He secured first rank in Master in Law and independently practicing as advocate in Bangalore in the field of IPR and civil litigation. He is a guest faculty in Ramaya College of Law, Bangalore. He is an international consultant in Coming International Center for Arbitration and Mediation is consulting in Karnataka, that is KSCST ISC campus Bangalore, and had been as honorary designated as a research associate Center for IPR Research and Advocacy, CIPRA, and Ministry of Industry and Commerce, GOI on IPR, National Law School of University, India University, Bangalore from August 2012 to March 2018. His papers and articles have been published in various books and journals. He has been invited as a resource person from various institutions and organizations too, and delivered guest lectures on the subject IPR by Ministry of Micro, Small and Medium Enterprises. Thank you, sir. So we are happy to have you as a today's speaker, sir. Now I'm going to hand over the session to the Mr. Vivek Anand Sagar. Thank you, sir.
Yes. At the outset, I would like to thank the institution, that ATME College of Engineering, Mysuru, for providing me an opportunity to to take the part in this particular program. I have been like the schedule which we provided over here is really a wonderful schedule which we have provided, which is an extensive and very in-depth understanding on each and every subject matter of intellectual property rights is what we have done here. Starting with understanding on patent system, okay, to the integrated circuits layouts. Today morning you have been told about patent search and drafting the claims, etc. And tomorrow you will also be understanding about the cyber interface with IPR and industrial designs. So my today's topic is on it's on the the copyright. When you say copyright, especially for the engineering, plays a very important role. How, where, when, and for what? So if these questions are the ones which we need to be understanding. So primarily the faculties who are at the engineering, when you say, sir, where do I get an interface with copyrights? Okay, so these are the few questions which comes into your mind I'll just share my PPT. Yes. Yeah. So when you say an interface for an engineering, how does it happen with copyright? What do I deal with copyright? Why should I deal with copyright? How does copyright helps me out? So these are the few questions we need to be answering. Primarily for a faculty to take an advantage of copyright. See, all these intellectual property rights so far you have been told. Okay. May I also ask you people, okay, with few questions. That is, I would just ask you a few questions. May I request you to kindly reply in the chat box. Okay. Yes. That is, what is an IP for you? The first question which I'm asking to you is, what is an IP for you? Can someone reply? What is an IP for you? In the chat box, I'm just looking at the chat box.
Participants, any answers?
Yes, I have also put a chat question that what is an IP for you? Or if I wanted to modify the question for you, I can also put up like this. Okay. Or what is an IP? Madam, is the chat enabled where I can see all the chats? Hello?
Sir, chat box is not enabled for the outsiders, sir, actually. So they can ask directly.
They have to ask me directly.
Yes, sir.
Okay. But what about those who are in the institution?
So they can, sir. They can answer, sir.
They can answer, right?
Yes, sir.
So I can expect few answers, right?
Yes, sir.
Yes.
What is an IP? ಅದು ಹೇಳ್ರಿ ಚಾಟ್ ಹಾಕಿ
What is the total participants who are there in the team, madam?
Sir, in the team, there are a few members, sir. Actually, live stream has been given in the YouTube. There we have many participants, sir.
Okay. So in the live stream, there are many participants, and in this team, there is very less. Do you mean to say?
Yes, sir. Well, there are very few.
Okay. Fine. So I could not do a what do you say, live chat with the participants, right?
Yes, sir.
It would be a bit difficult. Okay. Okay, if that is the case, then let me take another route, different method of explaining this particular session. Okay. Fine then. If that is the case, let me take in a different mode. Yeah. Now I have put you this particular. That's what my initially I was planning to ask you people that so far from 2 days you have been listening to this particular workshop. So this faculty development program. How or what do you mean by IP so far? If that was a question I would have asked, and many people would have been replying to my answer stating that, sir, an IP is something which gives me a protection. An IP is something which I own. IP is something which is my creativity. IP is something which where what do you say, a commercial return for my creativity or an innovation can happen. An IP is something which what do you say, support an inventor to generate commercial returns. So these are all the various kinds of answers I would have seen. And if there's a faculties, they would have also been specifically said that, sir, IP for me is something which a person who writes an article, and if I wanted to take that article content and write it in my article, then I need to take his permission. I need to quote his references. I need to provide references of the respective author, or give due credit to the author that who has written it. And this is what all the IP is. And if you would have also in the present days, for the faculties, there are also certain certain points to be noted down every year, that when you give your appraisals, then you need to provide how much number of papers you have presented, how many number of articles you have published, how many articles were published in international journal, national journals, etc. and etc. So these are all the things which you need to be providing in your institution. So when this comes into picture, see, when you write an article, and in some journal they would have said that if this article gets published, then all the rights in this particular respective article with respect to translation, adaptation, change, everything is being transferred to the publisher. This could have been a letter of transfer letter you would have been given to the author, given to the publisher at the time of submission of your paper. Right? So what do you mean by this? Sir, it is something which you own a property in a physical property in somewhere in a Mysore, in the heart of the city. Then it is something like, if you say, I'm going to transfer all the rights in this particular property to the publisher, that means it's almost equivalent to sale of your property, or transfer of your property, or assignment of your property. So when you assign, all the rights is been gone to the publisher, and he can do whatever he wants. What are the things the publisher does? He makes it into a journal, he makes it into a e-journal, he makes it into the books, he makes it into transformation, he may translate, he may do anything with respect to your work. So that is the thing which comes into picture. If that is the case, then you would be wondering, oh my God, is my article been getting transformed, translated, adapted, or it is being e-copies are given? So it's good, right? So that also indicates that there is a huge number of indexing happening. Various people refer you, and when the references starts, when the reader starts, when the follower starts, you get naturally huge amount of credit, you get the Scopus indexing, you get rating, etc. and etc. So these are all the things which matters a lot for a faculty. In this due course, is it fine for you to transfer all your right in this particular article? You say, wow, sir, if a Scopus is accepting my article and I'm getting a huge references, it's really very good, sir. But did they pay for you? Did they because they charge a huge amount of money for the subscription fees, etc. and etc. But did they charge you anything? So if that is a question, then you say, no, nothing was charged, and I think I'm being getting, but they are being charged and they are getting a huge amount of money. In that circumstances, won't there be a question to be aroused that yes, you should be entitled for certain amount of royalty for number of shares, number of circulations, etc. and etc. Today you see in a YouTube, if your channel is running very wonderful, there is amount of incentives comes to you. Everywhere you would have seen in the YouTube channels or in your YouTube videos that if you like this video, kindly click the below button, a share or like. So because this liking, sharing, getting notification results in a certain amount of revenue generation or certain amount of hits for the respective person. So that in that way he will be able to generate certain amount of revenue. So these are all the various methods which are there, different models which today we are coming up and playing with intellectual property rights just by putting. You must have known about J.K. Rowling, where she wrote this book Harry Potter. It was a story, and her story was when she submitted for the various publisher for printing. 5 publishers disagreed and throwed her book and said that who the hell will read about your book? So this was a situation, and consider at that point of time, thereafter somehow she struggled, and today her book, her stories are the voluminous stories are being transformed, translated, transformed into movies, characters, pictures, and translated in hundreds of languages. The movies is been translated in hundreds of languages. Huge amount of royalty are being recovered by this particular thing. You must have known about this Mickey Mouse. The Disney have a copyright over this Mickey Mouse, Goofy. So today, for if anyone wants to put it on your book, on your label, or on any kind of thing, are all being charged, and certain amount will go to the respective creator of that particular work. This is the power of copyrights. So all that which we need to be looking at is one single story, one single thing which can get a beautiful copyright and get huge amount of transformation, or one invention which gets a blockbuster patent, and that blockbuster patent and invention will become a huge commercial return in the market, and you get a huge amount of return. So one story and one invention is all which you need to be looking at for a blockbuster, right? So this is what the intellectual property rights provides you, the protection for your creativity and innovation. It gives you a revenue generation. It gives you a commercial returns for the work which you have done. Okay. So if these are the few slides which I would have asked the participants if they would have been responding to my chat questions, saying that what is the thing which you find in this slide? At least for those who are there in this particular chat, okay, may I ask you people, okay, may I ask you people that what do you find in this particular slide? Can anyone respond in the chat and chat box?
Flowers, I think.
Sorry?
Flowers.
Flowers. Okay, fine. You find flowers. Then?
River.
Yes, flowers. Agreed. What about others? What else do you find in this particular slide?
River.
Okay, you find rivers, you find flowers. Then? What about others? What is there in my slide? Very simple answers.
Wall paint.
Yes. You find flowers, you find water, you find sunshine, you find clouds, right? There are so many things. What do you mean by this? What else do you find? You find a picture, right? A creativity, right? An expression of an idea about the sunrise, right? So this is what you find in this particular slide. Then what do you find here? There is a fish, there is a colorful fish, there is a painting, there is once again an expression of an idea, okay, expression of love, expression of affection, right? So many things you find here. Okay, let me skip this. Okay, what do you find here in this particular slide? Once again, you can find two persons, a male and a female with colorful background, or a king or a queen, right? Once again, there is an expression. It's this art, this creativity, this work is nothing but this painting itself is a story. So why so much of power for this artistic work? And why you need to provide a protection for copyright for this an artistic work is because that it is not just a painting, but it is not just a painting, but it is a story. It is a life. It is a living. It tells a whole background. So that is the power of these things. So when this so many slides which I showed you, what are those? I would like to draw your attention to this one important case, that is the Reservoir Dogs. In the year 1992, There was a movie called Reservoir Dogs in a Hollywood movie where it was about the story regarding the it was about the gangsters who go and rob a bank, and how do they rob the bank is the story about it. Then what is the Bollywood opinion in Kante? Okay, copied in Kante, which they said, once again you can find Amitabh Bachchan and few other stars, where once again these are the gangsters who go and rob a bank. How do they rob a bank? So this was a story. Now in this whole background, do you think was the story of Reservoir Dogs in 1992 was copied in Kante? Do you think yes or no? You can put up your answers in the chat box or in your YouTube channel chat box or whatever it is. You just put up those. I will tell you further whether it was copied or not copied. Or some people also said, sir, I feel yes, the story are the one and the same. I think it is copy. But other people said, no, sir, I don't think there is a copy because of course there was a story about robbing a bank. That doesn't mean that no one should use the story of robbing a bank. So obviously it should not be a copy, and I think it is an inspiration, right? It's an inspiration for the people. Now in this particular 2 slides, what do you find? There is 2 posters. One, the dangerous Ishq and the Sex and the City part 2. So these two, this slides, do you find is something which is copied? Some people said, no, sir, it is not copied. Some people said, yes, it is copied. Here in Inception and Badlapur. Once again, is there any, copyright infringement? Some people said yes, some people said no. What about this? The PK and a Portugal musical album in the year 1973. The Amir Khan's, the PK and the other one. Was there a copyright infringement? Was there a copy? Yes or no? Once again here, the Ravan and the Batman beginning. Do you find something is copied? What about this? The Titanic and the Mausoleum. What about this? The King Arthur and the Hess. Aitraz and the Graduate. Rowdy Rathod and the Replacement Killer. So when you think of all these subject matter, lots of questions would have been arose in your mind that whether they were copy or not copy. So however, this particular portion I would like to just skip here for a minute, and I will just take you through the next slide of what is copyright protected. Before we telling that what is copyright infringement or what does not amount to copyright infringement, first we should know what is copyright protected. Okay, so what the copyright protects the creativity of an author, that is what he has written, an artistic work, and written a literary work, a musical composition, a film making, etc. So the protected creation terms is for the work. So in the copyright, primarily it protects the expression and not the idea, and the idea is as free as air. Okay, today anyone can breathe in air and out, so likewise idea is free, not the expression. Okay, so in RJ, this was one of the important landmark case that is called as the RJ Anand case versus Delux film. Though there was various opinion in the recent times, the courts have expressed their different opinion on this subject matter. Nevertheless, when the Supreme Court heard this particular case called as RJ Anand versus New Delhi, what happened here was that there was RJ Anand performed a play called as Hum Hindustani. What was this Hum Hindustani? Hum Hindustani was a movie where there was a play which was for a Rajasthani and a Madrasi, where these two people go and meet at New Delhi, and when they meet and when they study, during the study, once again there is a love between these two people. Once after this, when they had and once again the family members of both boy and girl disagree for their marriage, and their disagreement leads to quarrel among them, and once again they leave their parents and they get married. After they get married, they have a child. Once again the parents comes back and they live together, and that's the happy ending. This was a R.J. Anand's play called as Hum Hindustani, and this play was watched by this Delux film producer, and he saw, hey, R.J. Anand, this is a very good movie. Why can't we have a negotiation for transforming this play into a movie? So they sat, and during the negotiation, somehow the negotiation could not take place. In the due course, the producer of the New Delhi movie, that is the Delux film, comes out with a movie called as New Delhi. And in this case, what happens? There was a Rajasthani and a Bengali. So now it is not about Gujarati and a Madrasi. It is about the Rajasthani and a Bengali. These two people once again meets in the Delhi. Once again, when they meet at the Delhi, they are in love. They are once again approaches the family disagreement, regional disagreement, and linguistic disagreement, cultural differences, all these happened, and once again the parents disagreed, and once again they used to marry, they have a child, once again their parents will come back. So this was a story about the New Delhi. What? Now this R.J. Anand, when he found this particular movie done like this, he files a suit in the court stating that, hey, come on, see, there is an infringement of my right, my story. And without my permission, he has taken this and transformed it movie. And there are various tests where the court has come out with. There is a common man eye test. What is this common man eye test? Where you sit and watch a movie. Okay, you must have today in Karnataka, you must have seen lot of other language movies are being dubbed into Kannada language. Excuse me. Yeah, so a lot of movie is being transformed. So in these circumstances, if you watch a movie, and when you watch a movie A movie, and then you watch another movie, and you feel, or you say that, hey, come on, I feel there is a common man eye test. Okay, what is a common man? He feels that, hey, come on, this movie is nothing but than that. Then in such circumstances, it should be an infringement. Okay, so this is one test which the court has also come up with and said that yes, there is an infringement. Yes, likewise, let us see what happened in this R.J. Anand case. What did the court rule? So court, before telling that what amounts to an infringement or what does not amount to infringement, court first stated that that in what copyright does not exist. Copyright, there can be no copyright in an idea, as I have also told you earlier. There is no copyright in an idea, and the subject matter, the theme, the plot, or the history. History is what today the Pulwama blast, okay, or Operation Blue Star, or you take Operation Blue Star, or any such historical or a legendary fact or a theme or a method, subject matter. So if you are making a movie on how did this Pulwama blast took place, or you would have done a story, if you have done a movie on Bhagat Singh's how did he get the influence of the Britishers, and how did he got the sufferings of the people, and how he became rebel against the British government. So these are all the things which you cover up and make a movie, and that's a history. And if you make a movie out of it, then there are many people who made on Bhagat Singh. So should everyone come and file a suit against stating that no, Bhagat Singh is mine and no one else can copy my movie because I have done, or on Mahatma Gandhi ji movie. So this foreign history, foreign legendary fact, for an idea, for a plot, there is no copyright infringement. Oh, then if I take a movie on Bhagat Singh, I don't have copyright at all? Wait. So in such circumstances, if you bring a movie on something else, then the violation in such cases is, okay, the violation is in such cases is confined to the forum, the manner, the arrangements. and the expression of an idea by an author of a copyrighted work. Okay, so what is the thing which you are going to express? Okay, the expression, the form, the step by step, one after the other, who comes next, who comes next. So these are the form, manner, arrangement and expression of idea. That is what copyright is protected when. And further, the court also further said that when the same idea, but what if the same idea is being developed in a different manner? So in engineering, if you would have taken on some, what do you say, on extraction or filtering of a or extraction of an oil from a seed, you would have done a mission where you put up certain seeds such as neem seed. You put a neem seed, you process, you make some process, and by making such process, and you have come out with a new process of what do you say, extraction of an oil, then such new process, though there is already various process on extraction of an oil, and if you have developed on the same, okay, in a different manner, then in such circumstances, if you have written an article on it, then it is manifested that the source being the common. Okay, in this R.J. Anand's movie, Hum Hindustani and New Delux, what is that source being the common? Similarities are bound to occur. Can you people just think what could be the similarities which are bound to occur? One, what is that? What is that source being the common? What is the source? Can you tell me what is the source? The source are, that is the regional differences. Okay, what is a movie based on? Movie is based on the differences. Movie is based on language differences, regional differences, how these things came together, and what are the things which goes in and around. Right? So when the source being the common, that is two people from different region coming together. So if that is the case, in such circumstances, the similarities are bound to occur, that are such as, one, that they are bound to occur situations are, one, that there is a linguistic differences, regional differences, cultural differences. So these are bound to occur. Then the court should determine whether or not the similarities are fundamental or substantial aspect of the mode of expression adopted in the copyrighted work. For example, now you would have written an article, as I said, the extraction of an oil. When you have written an article on extraction of an oil, and you have an introduction, you have a literature review, you have an objectives, you have the usefulness, you have put up the hypothesis. Then you have made a comparative study with 1, 2, 3, 4, 5 people, how they are been extracting, and then you would have said in your article that, okay, if you adopt a different method, then the extraction where regularly if you would have extracted from 10 kg of neem seed, you would have got 1 liter of an oil. Then if you adopt my method, and you have written in your article that the process of extraction you do like this, you change the things, some of the things like that and like this, then there is an increase in extraction of an oil to an extent of 5 liters. It may not be 5 liters, but I'm going to say some 2.5, 3 liters consider. 3 liters you can increase in the increase in the extraction process. If that is a circumstance, then you would have written that the process, what are the new method which you have adopted, which has resulted in extraction of an oil. In such circumstances, what is the substantial portion? What is the fundamental portion of your article? Is an introduction is substantial portion or a fundamental portion, or literature review, or your comparative study, or your importance, usefulness of the study, importance of the study, what is the hypothesis? Is that's your part, or the extraction process which results in enhancement of enhancement of oil extraction, is that's a substantial portion? Then in the whole article, this or the result portion, that is your your substantial portion. Then he would have said, sir, I did not copy the entire article, sir. I just took the result portion. Isn't it that the substantial portion of someone's work? Then yes, if that is the case, if you have taken a substantial portion of someone's work, then it amounts to an copyright infringement. That's what the court said in this particular case. Likewise, this is also another such case. Okay, now especially in India, what is the thing which is happening with respect to movies and movie piracy? What are the steps which are being taken? If that was the case, then in the year 2014, the India realized that yes, at the international level, we are at a very backlog. That is in the Global Innovation Index. It tells about what is the index, what is the innovation level, what is the creative level you are in. So then in the India stood at 86th rank in its ranking. So India felt really very bad, and the Indian government, the government of India thought, no, this is not should happen. We should all gear up on a higher scale. We should facilitate the startups. We should facilitate the entrepreneurs. We should facilitate the inventors for for better protection of their IP and enforcement of their IP, especially the copyright industry, that is the film and recording industry, suffered a lot of huge amount of losses. You must have seen few years before where you would have today the movie comes up and in the evening you would have been able to view that pirated movies in your mobile phones or in your laptops. But is it possible today? No, because India has taken effective measures for curbing the piracy, right? Though you may say that, sir, it was freely available, sir, now it is not available. But what is a freely available? You cannot take someone's effort without paying anything for it. So that is where the government took lot of initiative, promotional activities, training and other things. So here is one such promotional activity which was taken. Yes. So as I said you here, to stop this piracy and support this, the film industry, because there is so much of people who are dependent, starting from production, cast, lightmen to the actors, the side actors, supporting roles, all those people are dependent on this. And if you does not support them, they'll be having a huge suffering. So this is what is being said, and we need to be effectively protected. So now here, what is originality itself is a big question. What amounts to an originality? Various people said originality includes the selection, judgment and experience. So even now you have taken some 5 content on what is the the 3D printing today. The world is also looking at where 3D printing, you are making a study on it and you write an article. So when you keep 50 articles before you read all the articles and pick up few ideas and components and contents over it and put it in your paper, that it requires certain amount of judgment, it requires certain amount of selection, it requires certain amount of experience. So this is what, if you have put in, that amounts to an originality. Originality is a requirement for a copyright. You must have known about what is the requirement for a patent. You would have known that patent requires novelty, non-obviousness and industrial application. Likewise, even copyright requires originality and expression. What is a design requires? Design requires novelty, and an article, a design applied to an article, okay, which is solely judged by the eyes, right? And trademark, what is the requirement for a trademark? Trademark requires a mark should be distinctive. when compared to other mark. That's all the trademark is required. So likewise, the copyright requirement is two: one, originality; second, it should be expressed in some tangible mode. How? It should have been written in your article, in your paper, or in your soft copy you have done, and this is what is required. Likewise, in few other cases, the skill labor judgment, the labor theory. So those are all the so facts are not copyright protected. As I said in the earlier case, Mahatma Gandhi ji assassination, Operation Blue Star. Okay, these are all the facts, and you cannot claim copyright over the facts. Okay, what are the things which is copyright protected? So your literary work, your artistic work, your dramatic work, your musical work, sound recording, and cinematography. These are the works which is protected under, or the subclasses of copyrights which is protected are, these are the ones. Here are the few examples. Here is an artistic work. Okay, what are in under literary work? What are the things which comes up? It is the novels, the poems, the books, the question papers. Do you believe the faculties, you prepare 5 questions for a question paper, that is copyright protected, right? Then answer script. Oh my God, faculties would have been really like, what do you say that, hey, what, the student answer scripts are copyright protected. They write whole lot of shit in it and mess up on various subject matter, try in and out, right here and there, and that is also copyright protected. Yes. Copyright does not have any standard that it should have a minimum standard that it should be wonderful article, even a dumb show, even any such thing is copyright protected. Okay, so here is a case. What happened once, one university, what they did in this particular case, what happens, the university takes up and say that to tell the students about its best model. What is the best model for? Writing an answer in an exam. They picked up one particular student's paper, said that this is how an answer should be, and this university started printing and fixed up fees for this particular book and started selling in the market. When they did this, the student who wrote the answer script filed a suit against the university stating that, hey, come on, this is my copyright on my answer book. You cannot put a particular price, make a copy out of it and started circulating in the market. You cannot do this. So this is what the student filed a suit to the university, and court said that, yes, what is the work which student has done? She has written an answer script and given to you. What is your job? You need to take down. You need to, what do you say? You need to take down those things and you need to provide the marks for the answers and not commercial returns out of it. And the court awarded damages and compensation to this particular student for this copyright infringement. And your abbreviations, okay, compilations, okay, or encyclopedia. What is a compilation? You must have known about Oxford Dictionary. Oxford Dictionary is what? A meaning for certain word is already there. and you can say that, hey sir, why should you provide a copyright for a dictionary? Because it's a meaning. Yes, though it is a meaning, though there is an abbreviations, though it is a compilation, there is an amount of skill, labor, and judgment. Hence, copyright is there for it. You must have seen in Oxford Dictionary, right? At the behind or the second page and the last page, they would have written that these books can be sold only in Bhutan, Nepal, and India, and not for any other place, right? That's what they have told. And tabular arrangements, database, data sheet, your engineering manuals, all your engineering manuals are copyright protected. Your software, the source code, the objective code are all copyright protected. What are the rights which you have? That is, you have a right to reproduction, issue copies, compilation to the public, translation, adaptation, include in sound recording and cinematography film. These are the rights which you have. So what is under the dramatic work? It comes under the dumb shows, the dramas, the written and recordings included in the other work. What are the rights which you have in dramatic rights? Once again, reproduction, that is to make number of copies and perform the same thing in various other places, and issue copies and communication to public performances, translation, adaptation, and inculcation in the this is another, that is the musical work. Musical works covers the work of music or melodies and hummings. Like for example, you know about this la 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 le le yo, right? So this musical notations, okay, melodies are the one is protected under the musical work, not the lyrics, because your lyrics primarily comes under the literary work. Okay, what are the rights you have? Once again, reproduction right, distribution right, adaptation right, communication to public, etc. Then here is the artistic work, the sculpture, okay, the stone carving, okay, your drawings, you all do various drawings and diagrams, right? Your what do you say, blueprints, right? The building blueprints or the machine blueprints, okay, diagrams, maps, the charts are all copyright protected. You must have seen in Google Earth, right, where they would have said that all the copyright, all the rights reserved with Google on this particular map. Engraving and photography. So these are the few examples. Yes, drawing rights which you have, once again, reproduction, issue copies, translation, adaptation, etc. So here in this particular picture, may I know who is the author of this particular work which he is doing? So that was a question I used to pose in the live sessions. So here the person who is writing, right, he is the author of the work. Yes. In case of sound recording, it is the lyrics. Here comes the lyrics, music, performance, okay, etc. And here comes the cinematographic film, composer's work, film, serials, documentaries. You must have known about Mahabharata, right? Mahabharata is one of the largest, what do you say, one of the very long time back. It was, so the person who produced that particular thing had a copyright over it on a films, serials, or on the documentaries. So what are the rights which he have? He has the right to make copies, communication to the public, to sell or give on commercial rents, or offer for sale, etc. Yes. So there is a two major concept in copyright. One, an author, and another one is the owner. Who is an author and owner? For example, if I write an article and give it to the publisher for publishing in a journal, then I am an author and they are the owners of my work. The journal owner is a one. Or if you say in a newspaper, okay, Vijay Deccan Herald or the Hindu, now who is the author? There are various people who writes article in that particular paper. So those who write an article, he is an author, and the owner of this article is the Times of India, where they pay these people for getting published in that particular newspaper. So he is an owner, right? So this is a thing which you are going to discuss. An author in case of artistic work, literary or dramatic work. In case of musical work, it is a composer. In case of artistic work, it is an artist. In case of photography, it is a photographer. Okay, in case of film and sound recording, it is a producer. Okay, and the ownership, in case of, as I said, in the newspaper, it is a proprietor, or if it is a journal, then it's the journal chief editor. Okay, persons coming, or if someone who has worked on commission, I give okay, I would say someone, hey, come on, take this particular money, give me some paintings for my business place. So this is what you do, and it's on commission. So I'm the owner, he is an author, and he transferred all his rights in that work to me. In case of employment and employer, etc. and etc. So this is one of the stone carving. Okay, what's the term of protection? So we understood about we so far. Let me give a small recap as to what are the things which we have done so far. One, we understood about first about what is a copyright. Okay, what are the works which is protected under copyright. We discussed about what is the issue regarding originality. What is the requirement of a copyright? That is originality and an expression. What is the few cases on what do you say, the to which the copyright is protected, the subject matter of the copyright protection, and idea and expression. Copyright protects the expression only and not the idea, and various works is what we have been discussed with 2-3 case laws. So now here we discuss about the term of protection. See, in the patents, you must have heard about that patent is provide protection for 20 years, and the integrated circuit, the designs protection is for 10 years plus 5 years. Trademark is for 10 years, and every 10 years you keep on renewing. GI, every 10 years you keep on renewing. So see, there is one beautiful thing in copyright, in the whole intellectual property rights. One, it has both limited, what does intellectual property creates? Intellectual property provides you a monopoly. Intellectual property creates a limited monopoly. Intellectual property rights creates a power for you to commercially exploit your rights. And if someone does not respect your right, then you can file a suit against him. This is what the copyright provides to you. So what is the term? So unlike patents 20 years, designs 15 years, trademark 10 years, and every 10 years keep on renewing, GI 10 years and keep on renewing. But here the copyright is one of the longest term of limited monopoly, which says lifetime of an author plus 60 years. In case of literary, music, artistic and dramatic work, it is lifetime of an author plus 60 years. Okay. So in case of what do you say, anonymous work, in case of photography, cinematography, sound recording or governmental works, it is only 60 years. Yes, you know about this. Mahatma Gandhiji's My Experiment with the Truth was one of the one which he had a copyright. After his death, he transferred his right to one of the society, and they were getting the royalty out of it. After the 60, that is 2010, he all the rights in his book was expired, and today anyone can copy the book and make copies, reproduction, circulation. Okay, so you can do anything out of it, but that means you cannot manipulate, change, rather make copies out of it as it is and give due credit to him only and use, right? So and now one of the important component over here which we are discussing. Okay. Yes, so now these are the things which we have so far discussed. So now let me come to the next portion. So far we have completed 1 hour of my presentation. Madam, in this particular this thing, is there any break which we can give, or we should continue as it is? Yes, madam.
Yes, sir.
Yes, sir.
Madam, is there a break kind of thing, or should we continue as it is?
No, sir. We can continue, sir.
We can continue as it is.
Yes, sir.
And what's my time? Till what time should I go for? Till?
Sir, we have a slot till 4 o'clock, sir.
Okay, no problem.
And even there are 2 participants, sir.
Sorry, madam.
And even they have joined, the participants have joined the session, sir, and even you can interact, sir.
Okay. Fine. So if that is the case, then can I put few questions, or can I take few questions now from the participants?
Yes, sir. Sure, sir.
Yes, madam. So after, because you need to have after 1 hour, we require some kind of a change in an environment. Otherwise, you have been continuously listening to my boring lecture. Hope so not, right? So can you, if you have any doubts, can you people just put up a few questions to me that I will try to answer your questions on the copyright. Yes. Should I go to the chat box, or you people will come online and ask? Anything is fine with me. Do you have any questions on IP, or especially on copyright, or even on any other subject matter is also fine?
So there are no questions posted by participants, sir?
Yes. There are no questions?
No questions, sir.
Okay. So if there is no questions, that means I should continue, right?
Yes, sir, you can proceed, sir.
Okay, ma'am. Fine. So if you people does not have any question, then I have a question for you people, right? So far you have seen what is the copyright gives you. If you have understood on few things, so what is the copyright which gives you? Someone can answer? Those participants who are joined in this particular Microsoft team, can you answer and tell me that what does copyright give? Can you put up in the chat box? Some answers, please.
Sir, it gives us legal right.
It gives you a legal right. Very wonderful. Then? What else? What else copyright gives you? Legal right for what?
To preserve our ideas so that no one can use it for particular use.
Excellent. So it reserves and preserves your idea so that no one else can copy it, no one can use it, no one can use without your permission.
Permission for particular
That is
of
what
years.
the copyright gives you. Fine. If that is the case, then then what about this? Okay, what about this copyright? I just go back here. Yes. 1 second. Yeah. So that is, so under the copyright there is two kinds of rights which is being provided. That is, one, an economical right, and second one is called as moral right. What are the economical rights? As I said, as madam said, protect, preserve and commercialize your right. Adaptation, translation, commercialization is the economical right. What is the moral right? What is the moral right? Moral right is a right where moral right is divided into two major rights. One, right to authorship and right to integrity. What is the right to authorship? Authorship is something which, even though, see, now earlier I said the term of copyright is lifetime of an author plus 60 years. What happens after 60 years? What happens after lifetime of an author plus 60 years? What happens to the copyright over that particular work? That means, see, this copyright or intellectual property rights has a limit, as I said, with respect to it, artistic, with respect to the patents, copyrights, the designs. So all these are limited rights. So that means your protection, that is, you can stop someone from using your work with the limited period of time, then you can enforce your right and stop him from using, right? So if you have a right to stop from using, can you do lifelong? Every time after 20, say lifetime of an author plus 60 years? No. That means after 60 lifetime of an author plus 60 years, then it shall come into public domain. That means any people can freely use your work without paying you money. That's all. But what the moral right provides you is, even after I have written and I am dead, and 60 years has been passed, but you should still give a paternity right. You should still give a right about for an author to say that this belongs to so and so person. Okay, if someone has written an article in the year 1901, then even though his copyright is expired, you cannot simply take, but rather you should give a reference stating that this article belongs to so and so person, and he is the author for it, and I am referring it over here, right? So that is what right to authorship or the paternity right is. So that is the right to paternity. Right to integrity is once again defined in India, and has in two major important cases the court has passed a very good ruling and given effective protection. What is this? Okay, can you people see here what you can find in this particular slide? Can someone say what you can find in the slide? Can someone see and say what is there in the slide? What do you find in the slide? Hello?
Yes, sir, it's audible.
Yes. What do you find in the slide, madam?
Sir, an image where there is an artwork along with few visitors.
Okay, there is an artwork with few visitors. Then, can you identify someone who is standing in the center?
It's our ex-Prime Minister, Jawaharlal
Yes.
Nehru ji.
Very good, very good, very good. So you find Jawaharlal Nehru in the center, and can you identify a person who is in a suit in the right side, the first person, the tall fellow, the black hair fellow? Can you identify someone? Can identify it?
No, sir, no.
Absolutely no one can find it out. Yes. I will say why. I'll tell. This was a case where here, as I said, that young fellow who is a black haired fellow in the black and white. Okay. So the Nehru, in one such, this is a place where Nehru thought that when people, this is one of the bhavan for a ministry of culture and tradition. So he thought that here we should have a kind of a situation where people come, when they come here, our culture, our rich heritage and tradition should depict. Hence, he appointed Mr. Amarnath Sehgal. I said that young person who is standing there is Amarnath Sehgal. Okay. He made various murals. Someone, madam, said that there is an artistic work. Yes, at the side you can find that artistic work is nothing but murals. He was commissioned to say that, okay, you are being paid a certain amount. Can you make this kind of murals for this particular building? And he made the murals, and after few years, once again, the government changes. After government changes, there are various changes which takes place, and later all the murals which was there on the wall were removed and thrown into a godown. So when all these works were thrown into a godown, and this particular Amarnath Sehgal, you can find on the right side top, there is a old fellow with all his black hairs has turned into white hairs, right? And who is wearing the white and white dress, he is once again the Amarnath Sehgal. Okay, he finds all his work were thrown in a particular place, and he felt really very bad. So in that circumstances, when he felt very bad, he said, oh my God, what is this? And he files a suit in the Supreme Court. One of the landmark case where he filed a suit in the Supreme Court stating that his work were mutilated. He had a right to integrity for his work, and the government should have not thrown his works into a godown. And the Supreme Court also expressed, yes, this Amarnath Sehgal has a right to, a moral right exists with him, or he has a right to integrity, that his work need to be respected, right? This is what the court said, and and court awarded a huge amount of damages to him, and directed the court to keep these murals, directed the government to keep these murals in a respectable place. This is one of the case. And this is another case. You know about this Mysuru Mallige? Of course, you people, most of them who are from Mysore, you must have known about this particular movie, which was a award movie, and which was produced by none other than the famous person Nagabharana. So when Nagabharana made this particular movie, this movie which depicted the social, the difficulty among the social and the love and affection. So this is what it depicted, the social behavior, and had a great respect, and because of this movie, and in one of the A certificate movie, they used the word called as Mysuru Mallige, and this amount to a great damage to his right to integrity, and Nagabharana files a suit against this particular producer, stating that his right to integrity is being damaged, and he has so hence they should remove the word Mysuru Mallige from this. And the court gave a direction, and they removed, and with the damage. So here is once again another case. Can you people see what's there on my slide? In this picture, can you see what is there in my slide? Can anyone respond?
Yes, sir. Yes, sir.
What do you find?
The artwork.
What is the artwork
Graphics.
consisting? This graphical or
computer graphics. Computer graphics.
okay, computer graphics. Okay, then what else you find? There is an artwork, there is a painting, there is a graphics. Then what else you find? You can find that moving of clouds, moving of the hills with the trees, right? Can you
Yes,
just kindly
yes.
correlate? Kindly correlate where this kind of pictures you can find.
Animation pictures.
Okay, in which animation picture you can find this?
Hollywood.
In which Hollywood movie you can find this? Can you specifically mention which is a movie where you can find this moving of clouds, or those arches, or the waterfall from a cloud? Can you tell me which is the movie? If you carefully see my slide, there is also a few prompting answers.
Avatar.
Very good. Yes. So these were the pictures. Okay. Roger Dean was a person who made this painting. Okay, in one of the small comic book. Okay, in one of the small comic book, he made this painting of moving of clouds, animals having so and so things. Okay, this is what he made, and you can find that the same idea was taken, and the expression, not only the idea but the expression, the moving of clouds as it is, were copied in Avatar, right? When this was copied, the court, and he files a suit in the court, and he says it is his copyright, and the United States District Judge, okay, Furman, awarded 50 million in damages to 20th Century Fox, the producers. So this is one of the landmark case where, for copying the pictures, court awarded 50 million in damage. Just imagine, my dear professors, that what is the potential of copyright? Copyright has a great potential of protection, right? So this is what you can find here. Okay. Yes. Harry Potter, yes, once again, very interesting movie, Harry Potter and Hariputtar. Once again, this is also once again a very interesting case where Harry Potter producers filed a suit on Hariputtar stating that Hariputtar producers stating that they are copied this particular things and characters, and this would amount to confusion. They also filed 2 cases simultaneously, one on copyright, another one on passing off for trademark. So when they filed this particular suit, court said that, hey, come on, how can you say that Harry Potter and Hariputtar is a copied one, or this amounts to an infringement on the part of Harry Potter, and there is a consumer can confuse. They said, the court said that, see, Harry Potter is a kind of not a common man's movie. It has lot of characters. You should know about what is their relation, what is their power, what are all the things they did. So these are the things which you need to know. And reading this Harry Potter book is something which is for a little higher strata people, kind of people who can understand. Absolutely, it is not understandable for me from a very long time. Nevertheless, so this was a case, and the court said that in that circumstances, there can be no confusion among customer that Harry Potter all the way came from various other places to India, especially to bring a Harry Potter movie. So this is what the court passed and said that, no, there is no copyright infringement, or there is no copyright infringement of or passing off for trademark. Secondary liability, vicarious, let me not deal with this. So all these time I said what amounts to infringement, what does not amount to a copyright infringement, what are the rights which you have, what is the term of protection. So these are the points which I have already told you. Now this is our next phase of entrance, which we are discussing about. Sir, if someone has copyright and if he has all right, then I, being an academician, should I take permission from him every time? Should I go and ask him permission every time? Should I pay him every time I'm using for an artist, for an educational purposes? What should I do? So here is an example for you, wherein if you are, there is a subject matter called as fair dealing or fair use. What is this fair use? In United States, if you use someone's work for, if your purposes, the nature, the amount, okay, and the effect. This is a test. The purpose, nature, amount, and effect is a test. In India, under section 52, it is been defined. What is that? So if your work is for, if your purpose is for research and for publication, for criticism, for review, then there is no any copyright infringement. Then if it is for reporting the current event, not copyright infringement. For educational purposes, a clear exception is being provided in the copyright that if you are using someone's material, you must have used some 10 books, collected 10 pages of their respective work and compiled it as a resource material and circulated to the only the limited students, only to the students, then there is no any infringement. And during the course of education, if you have provided the book and made copies out of it and given to the people, then there is no any copyright infringement. One of the important landmark case in this was in the year 2016 or 17. It was about the Delhi photocopying case. So here there was one photocopying copier in the Delhi, near the Delhi University, when all the students materials used to, if you would have said that I want on mechanical engineering, on some subject matter, and they used to give that particular whole material to him, to you, on a the Xerox price and this thing. So when this used to happen, the Cambridge University and Oxford University Press, they both filed a suit against the small copier and said that they have a copyright infringement, that he cannot do so without their permission or paying on certain royalty to them. And court said nothing doing. In India, we give more importance for education, and it's a democratic country, and they have all the students. It comes under the exceptional purposes, exception purpose, and hence it does not amount to copyright infringement. That's what the court said. Performance of a work for an amateur club, or if there's a performance you need to make in your college, okay, you play on certain songs, then it does not amount to a copyright infringement. Reproduction of your use of library work, reproduction for the use of legislators, judiciary, reproduction of any governmental work, okay, are all copyright exempted. So these are the few examples for you to make copies in accessible format for use. This is one of the very important point for you people to understand, especially for persons with disability or persons who are not able to, the blind persons who are not able to access the material. Then you can translate the work into audio form and there is no any copyright infringement. You can make it into an accessible form, where an international treaty in Marrakesh treaty, where this was one of the important treaty which came into existence in the international place for exchange of material from one country to another country on a accessible format, that is the braille form, audio form, etc. and etc. for the purpose of people who are not able to read the material, that is having a difficulty of big letters, small letters, etc. Right? So how do I can register my copyright? Here are a very simple process of registrations. See, actually speaking, unlike trademark, patent, GI, designs, where there is a compulsory registration of copyright is required, compulsory registration of work is required, but copyright says no, nothing doing. You need not register your copyright. There is an automatic protection. When the Berne Convention in the year 1886 came into picture, they also said at that point of time that there should not be any formalities, that they should compulsorily register the copyright. So that is where there is no any compulsory registration of copyright. Even if you have the only thing is it should be published. So you write an article, give it to a journal publication, book publication. On the book they would have written all rights reserved with the author, and it was published in the year 2019. That itself will indicate that the copyright is started from the day of its coming into light. So if you say, sir, I have not, I don't have power to publish in the journal, what should I do? Do one thing. Today you write an email to yourself and send it back to you. Keep it for yourself. That amounts to an publication. Okay, these are the few. There are various other such modes and method, but these are challengeable. That means anyone can challenge and say no, how can you? So then you need to prove. The burden of proof will be on you. So to avoid this burden of proof and to give a conclusive proof or conclusive evidence for this particular work, what do is you just need to file an application. If it is for literary work, it is just 500 rupees for your literary, artistic, dramatic work. If you are using this work for commercial purposes, then it is 2000 rupees. Okay, so your copyright will arise as soon as a work is being created. So there shall be no any legal need for registration. But if you register, then it is a strong proof, conclusive proof for, and it takes 1 month time from the date of today you file, you get a diary number, within 30 days you get a registration. Provided that no other person shall object for your work. Okay, and there is also a subject matter called as right to authors versus right to readers. Okay, this was also once again a very important question. These are the few issues which was raised in the international various places, that, sir, see, my engineering books are 50,000, 70,000 book. Can you always say that I should purchase and keep it? So it will be a very difficult. Aren't you stopping me from accessing to the education, accessing to the reading? So my Article 21 of my constitution, which give right to education, or Article 21A provides right to education for certain age. So these are under this MEDS, my fundamental rights is bigger or your intellectual property rights are bigger. So if you say these two are the very complicated questions or an issue which may arise, and then they said that no, for the sake of the readers, ultimately there is a fundamental rights, so that will prevail over the any other intellectual property rights. Even in the case of what do you say, this patent rights with respect to this pharmaceutical drug for cancer. Okay, when the cancer drug which came, which was 2.8 lakh rupees costing, and the person who applied for compulsory licensing, where I can manufacture the same drug for 8.5 thousand rupees, then the court gave the Supreme Court gave a direction saying that yes, you can make the compulsory licensing and you can manufacture and produce the mark for the lowest price, where if the patented product is not available, accessible and affordable. This is the primary basic reason. Or if there is in the pandemic situation, if someone comes out with them, then the court can give direction for further making and using. Okay. Yes. So as I said, a small process, automatic process for registration for copyright. I'll just state that is the filing of application, and with the required fees, you will be provided a diary number, 30 days mandatory waiting period. If someone objects, then objection filed. If there is no objection, then scrutiny by the examiner, then discrepancies, fulfilling those discrepancy, and registration and approved. If there is an objection, then send it back a letter to us, and with the opposite party, then reply back for them. Hearing will be there. You hear to the examiner will hear you, what is your argument, what is a person who will make an objection, his argument, and listening to both, if he feels that yes, it should be accepted, then it will be accepted and reply will be sent and you will be awarded. If it is not accepted, it will be rejected, and once it is been rejected, you have also an opportunity to go and approach the respective higher authority for redressal of your grievance and say that it does not amount to copyright, I need to be provided a copyright, and it will be granted. So these are the small this is a simple flow chart for registration, and so these are the subject matter which have been discussed with you so far about this subject matter on copyright and the filing procedures which is there in India for this particular copyright. Okay, so I think that's all I think I should be sharing with you people. Now I can take up questions if you have any. Okay, and yes, it's the time. I have done with my presentation. You can come up with any questions if you have in your chat box, or we can open up your mic and you can ask me a question. We can finish it off with the question and answer session also.
Participants inquiries.
So just I want to give a feedback.
Wonderful. Yes, sir. Go ahead.
So your presentation was wonderful, and the way that you presented your topic was really amazing. And
Yes,
we liked it, and also it gave more information regarding the copyrights. And this much of information we never knew. And it was a great presentation. And thank you for this wonderful presentation, sir.
Thank you very much, sir. This is our job at Karnataka State Council for Science and Technology. This is what we do to support the institutions at various places in establishing this intellectual property IP cells, in conducting this kind of FDPs, workshops, seminars for you people to understand on this intellectual property rights subject matter. Okay, we don't want you people to become an expert in this subject matter, because you are expert in your own field and you just need to have a basic understanding, because when you go ahead, use someone's material, write an article, use a process, then how do we effectively protect your work? So that is what is required. So for that, this FDP will surely help you, and I hope you have been enjoying this particular session from yesterday. Tomorrow, my colleague Mr. Nagarjun and Kodandram sir will once again amaze you all people on this subject matter on intellectual property rights. It's really a fun intellectual property rights. As I was telling earlier, what is an IP? IP is not just a subject. IP is a business. IP is seriously a business. In this pandemic situation, you can make a best utilization of intellectual property rights by creating a new things or creative or innovative subject matters, and you can benefit to the society as well as benefit you. So this is what the intellectual property rights provides you, and you can flourish yourself with IP. And I wish all the best to all the people to be innovative and to be creative. Okay, and so that's all whatever I have wanted to say.
Thank you, sir.
Thank you very much.
So finally, we are at the end of the session. So thank you for your stimulating presentation, sir. It was very effective information about the copyrights in a pictorial differentiation way. Finally, I take an opportunity to thank you on behalf of the management, principal, and faculty members of ATME College of Engineering in association with KSCST, Bangalore. Thank you, sir, for accepting our invitation and joining hands with us.
Thank you very much once again to all the participants who are there. I hope you have been utilized from this particular session. On behalf of Karnataka State Council for Science and Technology, I would like to thank all of them for providing this opportunity. Thank you very much. And namaskar.
Thank you so much, sir. Participants, the tomorrow session link will be sent to your respective registered email ID, and the feedback link along with the tomorrow session link will be sent to the registered email ID itself. Thank you for joining the session. Thank you so much.